Bon matin, tout le monde.
Good morning, everyone, and welcome to the 34th meeting of the Board of Internal Economy. I see that we do have quorum, so we shall begin our meeting. To begin with, we will be addressing the minutes of the previous meeting. Are there any changes proposed, any amendments, anything to be adjusted?
Desire for that, I'll presume any dissent for carrying that item number 1. Oh.
J'ai de la misère
I'm sorry, Chair, I am having difficulty hearing. Could you just speak in English for a moment?
Work now, Madame de Bellefeuille.
Non.
No?
Peut-être mon oreillette.
Can I ask somebody from technical support to? Thank you. Est-ce que ça va mieux, Madame de Bellefeuille?
Any better, Ms. de Bellefeuille?
C'est l'habitude, c'est l'habitude. Does it work for you now?
Oui.
C'est parfait.
Merci.
So, adoption of item number 1, l'adoption du procès verbal de la dernière rencontre.
The minutes of our previous meeting, thank you. Number 2, business arising from the previous meeting, Ms. de Bellefeuille. Thank you, Chair. Indeed, in the minutes, I do have something I'd like to follow up on. Could you tell us where we're at with comparing the level of services available to us for insurance coverage? With pleasure. We will ask Ms. Evangelides to provide us with an update.
Par vous, Monsieur le Président. Merci.
Hello, Mr. Chair, and thank you, Ms. de Bellefeuille. We have nearly finished our study, our analysis, and we will get back to you on the 28th when you next meet. We are still waiting for a few more details from the Treasury Board to ensure that we have all the information we need to provide you with the information you request. Thank you. I have another follow-up question, if I may, as follows. The interpretation resources, that item, I understand that indeed what I would like is that at our end of November or 4th of December meeting, we receive here the Translation Bureau to hear how their pilot project is going, the pilot project that they told us about the last time they appeared before us on the matter of hiring interpreters who would not necessarily have been accredited to interpret our parliamentary proceedings. There was a whole action plan, and I think the time has come to hear how that's going, and then we could put some questions. I think this would be very valuable. An excellent suggestion and totally appropriate. So we take good note of this. We will invite the Translation Bureau to our next meeting, surely before we break for the winter holiday. Any other matters?
On matters arising from the previous meeting? Seeing none, I have approval from everyone to proceed. Thank you. We'll move on to item number 3, travel expenses for witnesses appearing at the bar of the House of Commons. Les frais de déplacement des témoins comparaissant à la barre.
Travel expenses for witnesses appearing at the bar of the House of Commons, and I invite our law clerk and parliamentary counsel, Mr. Michel Bédard, to address us. Thank you, Mr. Chair. The House administration is seeking the direction from the board on the reimbursement of travel expenses of witnesses who appear before the House of Commons. As members know, witnesses are frequently appearing before parliamentary committees as part of their studies. When they need to travel, committee witnesses can have their travel expenses reimbursed. The measures respecting the reimbursement of witnesses' travel expenses apply only to committees. There is no measure for witnesses who appear before the House itself.
The last appearance of a witness before the House dated back to more than a century ago. That said, and as members will remember, last April, a witness appeared before the House. Also, there is currently a motion on the order paper that, if it were to be adopted, would result in another appearance before the House. The House administration is seeking a direction from the board as to whether the measures respecting the reimbursement of travel expenses of committee witnesses should also apply to witnesses appearing before the House. Also, in the special circumstances of an appearance before the House, we're seeking a direction on whether the travel expenses of their counsel should also be reimbursed. We'll be happy to answer any questions.
Questions et commentaires.
Questions and comments?
Mr. Scheer.
I'm not terribly familiar with how many times witnesses at committees have had to bring legal representation with them, but can you tell me what the current practice is for committee appearances with legal, in terms of reimbursing for travel expenses for lawyers to represent or to assist the witnesses?
Witnesses being accompanied by their counsel is not frequent before parliamentary committees, and the policy respecting the reimbursement of witnesses' travel expenses will not apply to their counsel.
Sorry, your piece wasn't working at the very beginning. So you're saying that right now, legal representatives of witnesses do not have their travel expenses covered. Is that
That's
correct?
correct.
Okay.
Madame Gould.
Can I ask, is the question here being put forward because it has been raised by someone or because the House is simply looking for direction? Like, where is this coming from?
We're seeking direction. It has not been raised. In the previous example that we had in April, the witness was a local resident, and also measures had been taken so that the witness could park on the hill. Now, as you know, there's a motion on the order paper that call for the appearance of another witness before the House. That person is not a resident of Ottawa. So in anticipation to the matter being raised, we're proactive in seeking a direction from the board. This person has already appeared before a committee and had to travel and did receive the form to seek reimbursement. So that's why we anticipate that the issue, if that person were to appear before the House, will likely be raised.
Mr. Scheer.
To your knowledge, in civil court cases, when witnesses are summoned, issued a subpoena, if they have to travel for that, is it normal in courts across the country to cover travel costs for witnesses who are summoned? Did you happen to know that?
Yes, for witnesses, it's common, and if a party were to serve a subpoena on potential witnesses, one of the measures is that the cost be covered, and that's for witnesses. If you're a party to a proceeding, then the rules are different. And of course, if you're a party, you will pay for your own expenses.
Questions et commentaires. Questions or comments? So, seeing none, Madame de Bellefeuille.
Mais en fait,
Well, this is an important discussion, one that's underway. In the situation we may be going through shortly, if such a person were to refuse to appear because it did not want to pay the expenses themselves, what would our recourse be as administrators of the situation? What would we have to tell them if we don't want to pay the costs either? What would the clerk or the chair say? Well, should there be no policy decided on, there is a House order then requesting that the person appear before the House. The person would have to appear. If the person does not appear because they're unable to pay for the travel cost or any other reasons, it would be up to the House to decide what the next steps would be. Ms. Gould.
My understanding, and correct me if I'm wrong, if someone were to be called to the bar and refuse to show up, wouldn't the sergeant at arms have to bring them in? Isn't there, like, what is the?
That will be an option, a logical next step, but that will have to be a decision from the House. So once the House realizes that the person who has been summoned is not there, the matter could be raised and a decision of the House be taken as to whether we have the sergeant at arms to go get the person.
So perhaps if I could, if we go back to what the boy could do if it chose to make a decision. Comme c'est écrit dans notre trousse
As we see in our information binder, the expenses of anyone called to the bar of the House and those of their attorney, if we decide to cover that, would be in accordance with the policies for reimbursing expenses of committee witnesses with any adjustments required.
From House administration?
It's not a recommendation. It's just that if the House were to choose to do this, this
Sure.
would be the form
So I
that we
guess
would
my
prepare.
question for the law clerk is this the recommendation that you're putting forward as to something that you think the House should do?
In terms of the wording of the decision, that's the recommendation in terms of if the board was to take a decision, that's how it should look like. Now, whether or not those fees should be reimbursed, including their council fee, that's a policy decision. And in the absence of direction from the boy, also being cognizant of the fact that it is politically sensitive, we're seeking a direction from the boy. We do not make a recommendation. But the wording that the speaker just read, that's how the decisions should read.
To put this in the right context, which we're all aware of, this would be the third time in 100 years that we would have called somebody to the bar. So you could, and for the 3 other times, or at least 2 other times that we could verify, and we're not certain about the case in 1931, 13 rather, dyslexia, is that we would not, both other witnesses were local, so it wasn't necessary, this question wasn't relevant. But this question could become relevant, and before it's asked of us, we want to get ahead of the ball. Madam Sahota.
I think we're all a little, it seems like you can tell that nobody really knows which side to take on this issue necessarily, but we're looking for some kind of guidance and precedence in other areas of the country. And from Mr. Scheer's questioning about how courtrooms deal with the issue, I don't know if there would be comfort around the table to handle it in accordance with the way our judicial courts handle it.
Michelle, and then I'll have intervention of Madam Gould.
Just based on the way that you phrased it, would an individual who comes to the bar be seen as a witness or as someone who is part of a case?
Not party. They would not be party, I think.
Yeah.
In this case, to answer your question, it would be both. The person is there to receive an admonishment for not answering questions that were asked of them at committee, to the committee's satisfaction. But part of the motion is for them to also testify and to answer questions of the House.
So they're seen both as a party and a witness, if you were to make a parallel to how the courts deal with us.
If we look in the judiciary, and I was referring to in the answering question, if you're a party to a process, and even if it's a civil contempt process, your travel expenses will not be reimbursed. So one option for the boy is that if the person is asked to appear at the bar solely to being sanctioned, then that no travel expenses be reimbursed. But if in addition the person is there to testify, then the expenses could be reimbursed. And if we're to apply and speaking to Mr. Shear's question, the same rules applicable to committees, then there will only be the expenses of the witness, not counsel. So that's one option for the boy.
Before we continue with discussion, I would just like to throw this out there. We've had now the airing of the issue. Would members like to come back to this issue in camera, or do they want to continue or make a decision right away?
I think we should make a decision because this was on our agenda last time as well. There has been some time to reflect. It's just because it's kind of new since we haven't really had practice in it since 1913, and now are facing this. I can understand why you want direction on that, but I think it seems what we're coming to is this a middle of the road type of policy, and maybe we could set some type of sunset clause on that to come revisit it if this does become a more routine occurrence than what we expect it to be. But for the time being, identify, what reason, what purpose the person is coming for, and then treat them either as coming to the bar to be admonished, in which we do not pay the fees, or as a witness, in which you would treat it like the way we do committee, where the witnesses come, their expenses get paid, but perhaps the legal, their attorney or their lawyer does not. I don't know, is that a happy medium? I'd like to hear from others at the table.
Mr. Julian.
Thank you, Mr. Chair. I've been listening very attentively to my colleagues. I cannot see a circumstance where being called before the bar is anything other than an admonishment, even if the witness is then being asked to answer questions that they refuse to answer at committee. And we have another case coming, potentially, another question of that nature that will be before you, Mr. Speaker, in the coming hours. So listening attentively, I understand the issue of regional disparity. Somebody from the National Capital Region doesn't have expenses that somebody who is brought to the bar from Saskatchewan or Alberta or British Columbia would have. At the same time, because it is a process of admonishment, I think it's fair to say it's not necessarily appropriate to reward that individual and provide them with additional resources. So I find this a difficult question. I would suggest the idea of providing support for their counsel sends the wrong message, because we are admonishing them if we bring them before the bar. Having reasonable travel expenses covered for the individual, I think, does provide that regional equity that in the largest democracy on earth we need to maintain. So my suggestion would be that we do reimburse an individual, not reimburse their counsel, and in that way ensure that we are being fair to somebody who is brought before the bar, even if they come from Western Canada or Atlantic Canada. But we're not providing additional resources that I think would be inappropriate.
Mr. Julian has put forward a point of view. How do other members feel about it? Monsieur Julien a présenté une perspective.
Mr. Julian has put forward a point of view. Is it supported? What do other members feel?
Madame de Bellefeuille.
Mr. Bellefeuille. I'd like to make sure that I fully understand Mr. Julian's suggestion. What he proposes is that we not reimburse people who basically must come to the bar of the House, and certainly not for their counsel. Is that the suggestion? No. I'll allow Mr. Julian to explain himself. Thank you, Mr. Chair. It is to reimburse reasonable travel expenses for the person themselves, but not for their counsel.
Madame Sahota.
I have a
Ms. Sahota.
because I believe at the beginning of your intervention, I understood something differently, that you don't see it reasonable to reimburse expenses as to how you began. But then the conclusion ended up being different. So I'm a little bit perplexed. I think you're now at the conclusion you're at is exactly, I think, what I had stated as well, that if they're coming to be admonished, we do not reimburse. If they are merely coming to be a witness, we do, and we do not reimburse counsel in any situation. Is that where we're at?
Thank you,
Mr. Julien.
Mr. Chair. What I said was, in all cases, they're being admonished in all cases. So even if they are providing additional testimony that they refused at the committee level, when they're brought before the bar, they're brought to be admonished. But I do understand that we are imposing additional penalty on somebody who has to travel from Saskatchewan to come to Ottawa to be admonished, as opposed to somebody who lives in the National Capital Region. So rather than providing what I think would be an undue level of support, including their counsel if they choose to bring a lawyer, I think it is fair to pay those reasonable travel expenses for the person. But understanding that in all cases, if they're brought before the bar, it's to be admonished and hopefully then to provide responses that they didn't provide at committee.
Believe that is a clear approach. How do members feel? Do I see consensus? Thinking of a very funny joke, which I can't say. But thank you. So I see that there is an agreement to move forward with covering the expenses, if requested, of a person who's coming from outside of the National Capital Region to the bar of the House, but not for counsel. Thank you. Colleagues, we're moving on to item number 4. Quarterly financial report for the second quarter of 2024-2025, le rapport financier trimestriel pour le 2.
The quarterly financial report for the second quarter of 2024-2025. Mr. Paul Saint-Georges is with us with Ms. Amélie Sacoté. Mr. Saint-Georges, the floor is yours.
Je présente le rapport financier trimestriel.
I am pleased to present the unaudited quarterly financial report for the second quarter of 2024-25. Cumulative expenditures are in line with the approved budget. Variance was planned for and is aligned with requests that were approved by the board. On the 30th of September 2024, operating costs, net and cumulative, of the House of Commons were $370.6 million. This is an increase of $29.2 million compared to the same quarter of the prior financial year.
$1 million is mainly due to cost of living increases and staffing for board-approved initiatives pertaining to security measures and transformation of parliamentary proceedings. There are no other unexpected variances to bring to your attention today, and I now welcome any questions the board may have.
Questions and comments. Mr. Bellefeuille. I do have a brief question, Mr. Speaker, regarding the $6.7 million to strengthen the protection of MPs. Does this include all measures that we carried this year that the Sergeant at Arms asked us for funding for? Is that what we see here? Yes, Madam. It covers all the measures taken. Thank you.
D'autres questions et commentaires?
Any other questions or comments? Would anyone like to move that we carry this matter? Ms. Gould?
Qu'on adopte.
I move that we carry the report.
Tout le monde est d'accord?
Is everyone in agreement? Thank you. We will now move to item 5, use of House of Commons resources for a video.
The use of House of Commons resources for a video. J'invite Michel Bédard à reprendre la parole.
And I will ask Mr. Michel Bédard to please take the floor again.
We're seeking a decision from the board respecting the use of our resources for non-parliamentary functions. Last September, the clerk received a letter from a political party stating that a $500 transfer had been made to Receiver General of Canada respecting the use of the Leader of the Opposition's office for an advertisement of the Conservative Party of Canada. The video is of a duration of 15 seconds, and the office is seen for about 1 second. We are informed that no other House resources were used for the video. To assist the board in its consideration of the matter, the administration assessed the potential value of the House resources at issue. The rental costs of a conference room in downtown Ottawa range from $500 to $1,500 for 1 day. Il y a deux précédents datant de 2010.
There are two precedents from 2018 and 2023 where the board considered a reimbursement of $500 as being appropriate remedy for the non-parliamentary use of a parliamentary office. In another recent precedent, the board established that amount at $1,500, but other House resources had then been used. We are seeking a decision by the board as to whether $500 constitutes an appropriate remedy in these circumstances or whether another amount would be more appropriate. Thank you. I'll be pleased to answer your questions. Thank you very much. Questions and comments? Ms. Gould.
So I'm sorry, could you just clarify which political party did this?
It was the Conservative Party of Canada.
Thank you. And what parliamentary resources did they use?
They use an office on the Hill.
Okay.
A parliamentary office on the Hill.
And do we know for how long they used the office to film this partisan video?
We know that the portion that was used in the 15-second ad was 1 second of 15 seconds.
No,
We don't know how long
Right.
the video was used.
Okay, but we don't know how long
the office was used.
they spent in the office filming this
don't know.
partisan video. So
We
the
don't have that.
Conservative Party of Canada used the office of the Leader of the Opposition for an indeterminate period of time to film a fundraising video.
It was not a fundraising video. It was
Point of
It was
order.
advertising.
Point of order. I think Ms. Gould might be confused. The fundraising video that was used as a precedent in our background was actually the Justin Trudeau's case where he used the Prime Minister's office to create a fundraising video.
Thank you.
My understanding on this one is that it was just part of a generic video that just had the 1 second
It was
clip in it.
used. There was an advertisement. It was
Before
a
we-
Conservative
before we
Party of
get into,
Canada advertisement.
Right, but the fundraising video was
Point
Justin
of order
Trudeau's
was raised.
fundraising.
Thank you. I have Madame Gould and then Madame de Bellefeuille.
So just for clarification purposes, they used this video to advertise on behalf of the Conservative Party of Canada using parliamentary resources.
That's correct.
Thank you.
Madame de Bellefeuille.
Monsieur Shears.
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. Speaker. Well, here at BOIE, we try to ensure that we don't enter into partisan debates, so I would ask my colleagues to please avoid doing so. So here we have a rule that was not respected. We cannot use House resources to carry out any activities other than parliamentary functions and duties. So it's very good. The person who carried out this activity has reimbursed the House to some extent. So what we're trying to decide is whether this amount is appropriate, an appropriate remedy. Mr. Speaker, I will say sincerely, and I don't think that anyone around the table will be surprised to hear this, that I don't agree with what is being compared here. I don't agree to this comparison. We can't compare a hotel room in Ottawa to the use of a office of the Leader of the Opposition or even of the speakers. These are important sites, important places, and there is no way they can be compared to a conference room or a hotel room. I've said this before. Moreover, the $500 has never been adjusted for inflation, for example. I think that we should request a considerably heftier remedy that would act as a stick, avoid that this occur again. You know, $500, that goes quickly even for a hotel room. So I think that we should change the threshold here and decide on a threshold that will really dissuade this type of behavior. Of course, the leader's office is not the Speaker's office, but it's certainly not the office of an ordinary MP. So I think that we need different levels of remedy. We need to send a clear message. I'm not rendering any judgment here because, you know, our lives are very complex. We need to work quickly, our staff and ourselves, and sometimes we may do things that we, you know, didn't think of ahead of time. We didn't realize we'd be breaking a rule. And here we see that this amount was reimbursed quickly, so we can see that there was not great intent to break a rule. But I remain dissatisfied with our setting this amount. I don't want us to take lightly the misuse of House resources. So if everyone around the table agrees on $500, I'm, you know, not going to take this further. But if anyone thinks that what I'm saying makes some sense and would like to discuss this further, then I will put forward a different amount. Otherwise, we'll stick with the $500, and that will be the standard. If you break the rule, it's going to cost you $500. If you think it through, though, maybe it's costing more would be a better argument against this sort of behavior. That's my position, Mr. Speaker. Thank you, Ms. Benefit. Questions? Mr. Scheer, to be followed by Mr. Julian.
I want to respond to the comments from my colleague. I do disagree with her assessment that it's not appropriate to compare to rooms that you could rent at hotels. With all due respect to the great work that was done into creating this space as a temporary place for MPs to occupy while we're waiting for Centre Block to be finished, most of the offices in here are very nondescript. They don't have those historical features, and they don't add much to a video or an advertisement. If it was in the chamber, I think she might have had a point, you know, because that is a unique, even the temporary chamber is a very unique and iconic and a very obvious place of what it is. But when you look at some of the conference rooms and the boardrooms that are available in hotels around the city, I would say most offices have a very comparable feel to it. I think we should view this into two separate parts. One is there has been a body of evidence or precedence on appropriate reimbursement. Because remember, that's what this is supposed to be. It's supposed to be to say if you had to go out and book a commercial space to do what you did, it would have cost. We have the range there in front of us, and so to make sure that parliamentary resources weren't going into partisan activities, the House recoups that. I believe that if members feel that's unsatisfactory, that's fine. We could maybe have a discussion on that on a go-forward basis. But in this case, we have an incident where it was self-reported. It was realized after the fact. I can tell you that the Conservative Party has space nearby. This isn't something that, you know, they needed a particular shot in a parliamentary building, and it's to me this is akin to an oversight that when a member submits a whole bunch of receipts for something, and maybe something should have been categorized as a personal expense, and it gets in, they reimburse, and the House of Commons has always accepted that. So I would suggest that, given the Prime Minister's, Justin Trudeau's, use of his office when he shot an actual fundraising video that was used to solicit donations. That was accepted at that time. I would make the argument that the Prime Minister's office is more of a heritage building, is more obvious as to what it is than what the Leader of the Opposition's office is. That was accepted at that time. I was the subject of a similar situation where an oversight was made in terms of scheduling various video shoots. Mr. Speaker, you had your situation. I think that this is very straightforward. This is the type of thing that we can imagine many of our colleagues forgetting the rule or not being as attentive as might be optimal. And so this is a way to make sure that when they do that, Canadians can have confidence that parliamentary institutions and resources aren't being used inappropriately. I think $500 is fine. I would propose we accept this in keeping with past precedents. If Madame de Bellefoy believes that this is something that needs to be more heavily sanctioned going forward to make members think twice, I'd be happy to entertain that conversation. But I think when these things happen, if the reimbursement is made, the situation is kept whole, and I think that's where it should end. So that would be my proposal, that we accept the self-reported proactive $500 payment in keeping with past precedents.
Thank you, Mr. Chair. I have Monsieur Julien, suivi par Madame Sao.
Mr. Julien, to be followed by Ms. Sahota. Thank you very much, Mr. Speaker. Let me begin by saying that I fully agree with Ms. de Bellefeuille to the effect that the BOIE should always be a place where we leave our partisan hats at the door before we come in to share time here. It's really important that we not become partisan in our work here. We are working to support the entire institution of the House. Very important.
$100, I don't think sends the message. My colleague, Mr. Scheer, has a long experience, and he did say the issue of forgetting a rule is something that is the case here. Fair enough. I think a larger fine, I would suggest $1,000 moving forward. It means that it is a very, very clear message so that no parliamentarians forget the rules. I mean, the rules are very clear. We cannot use taxpayer-funded space, whether here in Ottawa or in our constituency offices, for partisan reasons. And so I think $1,000 is an appropriate fine to levy to make sure that we do not forget the importance of that rule. I think $500 from a few years ago may have been appropriate. I think we need to revise that now. And I would support $1,000 as a reasonable amount. It was self-declared. That's important. I think that's a mitigating factor. But I do think we have to send a very clear message about the use of public resources.
Merci, Monsieur Julien.
Thank you, Mr. Julien. Ms. Sahota.
I'll start off with addressing the last point that was just made. I think even Mr. Scheer has said, and I agree, that if we want to have a conversation about changing up the fee or penalty, I guess I should say, the penalty that's imposed, that's a separate conversation that we should have. Maybe perhaps after deciding whether, after moving on from this item, either today or at another date, and set that on the agenda so that we have a clear rule in place moving forward. I'd be in support of having that conversation and coming to some type of consensus on that. As per why this was imposed in the first place, and even the previous cases that we've seen, I'd like to have a better understanding because I feel the reasoning that Mr. Scheer is providing here today is somewhat different than the reasoning I believe that this penalty is imposed. It's not the nature of the wall behind you or of the hallway, but more regarding using taxpayer-funded resources for partisan purposes, whether it be partisan advertising or partisan fundraising, that if you had used and spent money for that anywhere else, there'd be some kind of cost involved. And so using taxpayer resources is the reasoning that we're imposing these penalties, not because, the West Block room is not as valuable in Mr. Scheer's opinion as one that is in Center Block. Could you give me some insight as to how we derived at the penalty in the previous cases?
So before I pass the comment back to Monsieur Bédard, just so that all members are clear, the $500 to $1,500 assessment is not a penalty. It's an assessment for resources which are being used. It's a reimbursement. So I just want to make sure that we're all using the same language. Monsieur Bédard.
Respecting the comparison, it was the comparators that were used was available for rental in the Ottawa downtown area. I'll ask my colleague from Finance Services, the Chief Financial Officer, if he has more details on the comparators that were used in previous and in this case.
Yeah, back in 2018, we went through the same process of evaluation in terms of different types of rooms, and at the time the range was $350 to $1,000, and that began the discussion in terms of arriving at the 500.
A follow-up on that, though, what was the historic nature of the building taken into consideration, or was it the fact that you were using taxpayer resources and that needed to be reimbursed? Like, was the basis of coming to this type of conclusion that, or was it based on the fact that it was the historic nature of the building?
At the time, 2018, even, I would say probably the most recent ones, we did not consider the historic nature of the building. What we looked at was the utilization of the resources, inclusive of the square footage, space, similar type size that would be available anywhere, with whether or not it's at West Block or whether or not it was available at a conference center within Ottawa.
If I may add, in terms of other resources that may have been used when we're dealing with such cases, one of the questions that is asked is always whether or not any other house resources were used. And in this case, it appears that the only resources that were used were the premises.
Thank you. That answers my question, and it brings me to the conclusion that, as has been imposed in previous cases, we should move forward with the $500 reimbursement in this case, just as we have in other cases, and that Mr. Scheer's comments about whether, a certain type of room was used in the past when this type of occurrence happened versus the room that was here. Like, I don't think there's any purpose for those comments, and they don't add anything to this conversation other than taking partisan jabs, really. We can see that Mr. Poilievre has made a similar mistake, and it's good that he is owning up to his mistake of using taxpayer funded resources, and that the reimbursement has been made. And I think we are open to having the discussion moving forward, whether the penalty should be increased if other incidences like this occur.
Monsieur Bédard? Okay, sinon, on va passer à Monsieur.
And if not, we will move to Mr. Scheer and then Ms. Gould.
I appreciate the part of the comments from my colleague, Ms. Sahota, and I certainly do agree that the more we can keep partisan comments out of the board, the better, more productive it is. My comments about the nature of the building were not meant at all to be partisan. My thought process is, and you can disagree if you like, but what I was thinking of is it's not so much that using these premises costs the taxpayer extra money. The buildings are built; they exist. There's no meter running when you walk into the building. Exactly. There's a benefit to a party, and that's the lens with which we look at it. So that's what I was thinking of in terms of the nature of the room itself. I could find many rooms around walkable distance around here that would look awfully similar to the rooms that are up on the 4th floor. So the benefit to the party to have that space be where that part of the video was shot would be very comparable to rooms nearby. My point about more iconic buildings was that if you wanted to create a look or a feel in a video of the chamber, of a ministerial office, a historical office, then I think that dollar amount would change, because it would be very difficult to replicate that type of a backdrop or a set. So that's what my comments were. It wasn't meant at all to be, one mistake was more grievous than the other. I'm just thinking through the lens of what benefit did a political party get from the physical location. So that's the intent was just more of like how to think this through and how to link a dollar amount to something. I appreciate the indication of agreement on applying a similar remedy here as has been used in similar cases. And if we want to bring this back as a go forward, I think it is important, if we are going to change something and create a new precedent, that maybe that be communicated proactively for members so it sharpens the mind and adds something to their checklist before they do something. So I would appreciate that conversation being held separate from the current case. So.
J'ai 2 autres personnes sur la liste des.
We have 2 more people on the speakers list, and then I hope we can wind this discussion up. I have Ms. Gould to be followed by Mrs. Julian. Thank you, Mr. Speaker. I simply wish to state that we propose to support the $500 proposal that's now before us, but to discuss this further in a future meeting, to see to it that the amounts are reasonable and in line with the current economy.
I believe we may have a consensus then on $500 for this case. I'd just like to propose that we make it $1,000 in any future cases. Rather than having the discussion, I think Madame de Bellefeuille's comments are well-founded. And I think what it sends is a very clear message that people shouldn't forget the rule. So that would be my, I agree with both Ms. Soda and Ms. Gould about $500, and Mr. Scheer in this case, $500, but I think we can make the decision to make it a higher amount moving forward.
So thank you, Mr. Julian. I see Mr. Garrison, final comment, or I hope.
Yeah, I just want to make sure that we continue to distinguish between the difference of reimbursement versus penalty. To Mr. Julian's point, I just find as though the issue might be clouded a little bit, just the way I'm hearing it. I mean, I think that both are appropriate. I think that if we deal with this situation the way that we've dealt with previous ones, but if we want to establish a precedent moving forward, it would be best to establish a penalty and then a reimbursement that is more subject to the use of the space that it occurred within. Because one is the deterrent and the other is the reimbursement of utilizing the resource. And I just think it's important to distinguish between the two. Like if you used a room and it's only $500, but then you used, it was done somewhere else that you might put the value on it a lot more, then we're just going to be back here having the discussion again later about why it should be upped. Rather, I think it would be better to set a penalty for doing it, which would then be accompanied by the utilization of the resource.
All right. So thank you very much, Mr. Garrison. I see no other discussion on this matter at this point. We're going to go to Monsieur Bédard.
If it's the will of the board, we could come back at a future meeting proposing a principled approach to these cases. Also, we heard the term penalty, fine, and it's important to consider that the BOI jurisdictions in terms of penalty and fine are limited for constitutional and legal reasons. So if it's the will of the board, at the future meeting, a briefing note could address and make a proposition as to appropriate options in the circumstances when the bylaws are breached.
Do we have consensus then to two things? One, to proceed with to accept the $500 reimbursement, and B, to come back to the board at a future meeting to discuss this issue. And we'll lay out several options that are available to us within the parameters of what we're able to decide here at the Hill. Madame de Bellefeuille, le dernier mot.
Je suis bien d'accord.
Mr. Bellefeuille, you have the final word. I certainly agree with what's being said, but we understand that our staff and the administration has a good deal of work to do right now. We understand that this is a good thing, but not urgent. We did not agree to discuss this at our next meeting, but we will get back to it at a future meeting. Do I have consensus? Bravo. Ladies and gentlemen. Mr. Scheer, something to suggest, sir?
It's not, no, très, très vite. Je
Let us not see
Yeah, really quick.
jaws of victory here.
No. This is a new item. I just wanted to put on the radar, we have had several members who are engaged in the FMO pilot project for Members Portal, bringing some feedback to us with some concerns and some negative experiences. And I understand it's a pilot project, so that's why they're there. But I was wondering if House Administration could either inform parties' reps at the board here how their feedback will be incorporated, and the things identified as being cumbersome or problematic, how it'll be addressed. And I would like to flag this for a future item, that we get an update from House Administration when they're prepared, and when we can maybe go back to our respective caucuses with actual specifics, so we can make sure that a new system is ironed out before it's launched.
Monsieur Saint-Georges.
Mr. Saint-Georges.
Come back to you. We have been tracking all the feedback within FMO, and we have been using that and revising the approach for the next phase. So that involves your comments, your experiences, and we're moving ahead with an approach that I would say is more centered on the member. So in terms of the change management as to where you need to be probably a year from now on the system. So absolutely happy to bring that back.
Thank you very much, ladies and gentlemen. Meeting adjourned.